Hello, my name is Stephen Labiak with the law offices of Stephen Labiak in Fresno and Visalia. Two types of law that often intersect are bankruptcy and divorce. Often when people are getting divorced, one of the reasons is financial worries. This may mean that a bankruptcy may be a good option for both people to get a fresh start. A common question is, well, should I file bankruptcy before or after divorce? In most situations, I'd recommend before, and here's why. The easiest reason is if you are filing together as a couple, that's usually only one bankruptcy fee, not two. Another reason is there's going to be no issue on dividing the debts when you go see your divorce attorney. All your debts are going to be in one pile. If the bankruptcy is done correctly using a qualified bankruptcy professional, there'll be no debts to divide when you do the divorce. This means there'll be less issues to haggle over with your divorce attorney, and hopefully that'll help keep the costs down on that. There are some downsides though. One of which can be is if you're both having to earn more money to be able to maintain separate households, yet you file together, there can be income issues. Another downside is if you're having a divorce and it's particularly nasty, yes, you're going to have to talk to each other a couple times and you may see each other in court. There can be upside to filing bankruptcy after your divorce, one of which is you now have two separate incomes and two separate households. What this means is if you're having problems qualifying because of your family size is too low and you both make too much money, by splitting that up it may make it easier for both of you to qualify. Another benefit, of course, is at this point if you're divorced and then you file bankruptcy, you don't have to talk to your spouse anymore. The downside of filing bankruptcy after you divorce is you need to understand that debts that you agree to take as part of the bankruptcy proceeding can be objected to by your ex-spouse and therefore not be discharged as part of the bankruptcy. For example, if you have a large Chase Visa bill for $50,000 that your spouse ran up but you agreed to take in the divorce proceedings, you cannot bankrupt that debt. Your spouse may object to that debt and you will still be liable for that debt even if you filed bankruptcy and even if it would have been dischargeable if you were still married. Another downside is if for some reason there was not a fair split of the community property assets, the bankruptcy trustee may go back and look at your assets as they were before the divorce, and you may end up losing assets even though you didn't take a fair share in the bankruptcy. Another downside, of course, is that between the two people there will be two sets of bankruptcies. Overall, for most of my clients, I recommend filing bankruptcy before filing divorce. It'll make the divorce cleaner, it usually makes the bankruptcy easier, and just for everybody, the outcome is usually a lot better. If you have any questions about this, feel free to give me a call at 559-274-2868. Thank you.